Hello, good afternoon. So, we are going to go over Wayfarer's reply brief to Harco's opposition to their motion to dismiss or stay. So, obviously, this is in the Harco v. Wayfarer lawsuit, Harco being the insurance company. So, let's get into it. I have already done a video on Wayfarer's motion to dismiss and then Harco's opposition, which I did that one earlier. So this is their reply that was filed on the 12th of January. It's obviously taken me a bit of time to catch up with this kind of related lawsuit because there's just been non-stop in the main action with the motion for judgment on the pleadings and the motion for summary judgment and spoliation, like about 6 other sanctions motions. So I'm now I've got through the main stuff, and we've got about a week or two before anything major happens in that lawsuit. I'm able to catch up with these kind of side lawsuits that are related. I've got 2 more very short videos to come. I will do them separately, I think. I think it's better to do it separately, yeah. So I've got 2 more videos to come today. I did do Harco's opposition earlier. This is now Wayfarer's reply. Harco have filed for leave to basically file a SIR reply, and Wayfarer have filed to oppose their request to file a SIR reply. So those will be the 2 additional videos I will do later on, but they're just short letter motions. So this isn't going to be too long either. It's about 10 pages long, which is not much really in the scheme of legal filings. Okay, so we have preliminary statement. This insurance coverage dispute belongs in California state law, not in this federal forum. Under the Brillhart Wilton abstention doctrine, this court has broad discretion to dismiss or stay declaratory judgment actions in the interest of comity, federalism, and judicial efficiency, particularly when, as here, parallel state proceedings can resolve substantially overlapping issues governed by state law. The California action and this case both concern the coverage for the Lively lawsuit, involve similarly situated insurers, and implicate similar coverage disputes. Courts do not require perfect identity of parties or claims to find actions parallel. What matters is the significant overlap of issues and the ability of the state action to adjudicate the rights at stake. A standard readily met here. Abstention is especially appropriate because disputes over insurance coverage are quintessential matters of state law that federal courts routinely decline to decide when a state forum is available and adequate. Harco is not statutorily entitled to a federal court forum because federal courts have broad discretion in determining whether and when to entertain an action under the Declaratory Judgment Act, even when the suit otherwise satisfies subject matter jurisdictional prerequisites. Here, California has the most substantial relationship to the coverage dispute. The policies were sold in California to California insureds. The underlying facts and witnesses are in California, and California law will govern. Should this court invoke its discretion to abstain from the state law coverage dispute, the insureds will join Harco in the California action where it belongs. All the salient Brillhart-Wilton factors favor abstention. Harco's claims can be satisfactorily adjudicated in the California action. Harco concedes it is amenable to service and could be joined in California. And proceeding in this court would create duplicative piecemeal litigation and risk inconsistent rulings on overlapping issues, precisely the result Brillhart-Wilton seeks to avoid. Harco's counterarguments do not warrant a different conclusion. The filing order is immaterial when, as here, the actions were brought close in time and involve concurrent state and federal proceedings. Nor does abstention require that identical parties be aligned in both actions that are Federal Rules of Civil Procedure Rule 19's necessary party standard be met. The circumstances also show classic forum shopping by Harco, which rushed to file in this court to secure a perceived advantage, rather than permit the California court to resolve California insurance law issues arising from California policies and parties. Not only have Harco's actions created judicial inefficiencies, but they have also prejudiced the insureds by forcing them to litigate two duplicative coverage disputes in two different fora, while still defending the lively lawsuit. This court should exercise its discretion under Brillhart Wilton to dismiss or at minimum stay this action in favour of the ongoing California action. Okay, so the argument. Application of the Brillhart Wilton doctrine is proper and supports abstention in this insurance coverage dispute. The Brillhart Wilton doctrine governs a court's broad discretion when considering declaratory judgment actions. This doctrine is couched in permissive language of the Declaratory Judgment Act and is aimed at preventing district courts from indulging in gratuitous interference. Harco argues that the California action is not parallel proceeding because Brillhart Wilton applies only when there are duplicative and parallel actions pending between the same parties. That is wrong. Perfect symmetry of parties and issues is not required. Rather, parallelism is achieved when there is substantial likelihood that the state litigation will dispose of all claims presented in the federal case. There is no requirement under Wilton abstention that each party to the federal case also be a party to the state case. Okay, so it's a good start we're off to here. Harco's narrow reading of parallel proceedings is contrary to this court's more flexible analysis. It is sufficient when the factual and legal issues in both cases overlap significantly. Even if the claims asserted are not identical, if the claims raised in the federal proceeding could be satisfactorily adjudicated in the state proceeding, abstention may be warranted. Harco lists cases that reflect a pending parallel action between the same parties in arguing that fixed parties are required for this analysis. But these cases show only that sometimes the parties are the same. It does not undercut courts' recognition that there is no rigid requirement. Just because one action is merely a subset rather than exact duplicate of the state court proceeding does not diminish their concurrent nature. Here, both the California and New York actions concern insurance for the lively lawsuit. While the parties and specific coverage questions may not be identical, both involve the insurer's duty to defend and overlapping coverage defenses. The underlying facts, allegations, and pleadings are the same. Further, the Harco policies contain exclusions, i.e., conduct, bodily insurance, property damage, similar to those in the policies at issue in the California action. Once Harco is joined in California, which the insureds fully intend to do so should this court abstain from this dispute, these overlapping matters can and will be decided in a single proceeding. Moreover, insurance disputes generally present strong reasons for a federal court to abstain, because such claims are intimately tied to matters of state law which are being litigated in state court. The Brillhart-Wilton factors favor dismissal or stay. While the Wilton court did not lay out a bright-line test for abstention in favor of state court litigation, it did endorse the non-exclusive list of factors set forth in Brillhart. In exercising its discretion, the court must look at more than just the mechanical application of the declaratory judgment standard and consider the litigation situation as a whole in determining whether it's appropriate for the court to exercise its jurisdiction over the declaratory judgment action before it. Harco's claims can be satisfactorily adjudicated in the California action. Harco argues that its claims cannot satisfactorily be adjudicated in California. Why not? Okay, I like it straight to the point. Why not? A California court can interpret policies issued in California to California insureds. In weighing whether a claim can be satisfactorily adjudicated in state court, this court considers the subject matter of the parallel proceedings. The same thing is true here. This court's discretion in determining whether a claim can be satisfactorily adjudicated in state court is not limited to instances involving a nearly identical overlap of parties and issues. Because California State Court is an adequate and fair forum for Harco, it is well within this court's discretion to determine that Harco's claims can be satisfactorily adjudicated in the California action, and this factor favors the insureds, not Harco. Harco misrepresents Brillhart Wilton's necessary party factor. Harco incorrectly reasons that because it is not currently a named party in the California action, this court should not abstain. However, the Brillhart-Wilton analysis is prudential and focuses on whether a party has a fair opportunity to adjudicate its claim, not a rigid application of Federal Rule of Civil Procedure, Rule 19. Harco's current absence from the California action is not dispositive because the core inquiry for abstention is whether parties are amenable to process and can be joined for a comprehensive state court resolution, factors easily met here. The Second Circuit has also confirmed that the Brillhart-Wilton factors are discretionary and governed upon open-ended practical factors, not a rigid necessary party test. Even in circumstances when a declaratory judgment would serve a useful purpose in clarifying and settling the legal relations in issue, or terminate and afford relief from the uncertainty, insecurity, and controversy giving rise to the proceeding, district courts retain broad discretion to decline jurisdiction under the DJA. Accordingly, abstention is not governed by any rigid civil procedure test, but rather by broader principles of federalism, judicial efficiency, and fairness. These principles strongly favor the insured's request for abstention here. Harco admits it can be sued in California, which favors abstention. Harco admits it's amenable to service in California and could be added to that lawsuit. Contrary to Harco's position that this factor is of no weight, the Brillhart-Wilton analysis strongly considers whether parties are amenable to process in the state proceeding to ensure a fair adjudication. Based on Harco's own admission that it can be joined in the California action, this factor weighs in favor of abstention. It's a good argument. That's good. Harco did say that. Moreover, Harco's claim that the insureds are litigating the Lively lawsuit in New York ignores that the insureds were sued in New York by Ms. Lively. All relevant contacts are with California, not New York. And that's fair, because obviously Wayfarer initially started they initially sued the New York Times in California. They agreed to move the case to New York, for ease and convenience, because Lively had already sued in New York, and there was obviously that hearing on the 6th of February where Friedman said, well, look, instead of having, related lawsuits on, the two different sides of the United States, let's just bring them all one together. I think it's fair for Wayfarer to argue, well, that's not us agreeing to be sued and to sue in New York. So, and going by Harco's, well, we were the first to file argument, Lively filed first against Wayfarer in New York. So they were sued. Okay. And Harco can receive a fair adjudication in California. Maintaining Harco's suit in New York federal court will create duplicative and piecemeal litigation and risk inconsistent results. Harco does not contest that coverage for the same underlying lively lawsuit would be at issue in two different fora, which could lead to duplicative and piecemeal litigation. Even Harco's own cited case, the Dunkin' Donuts franchise restaurants, recognizes that piecemeal litigation occurs when different claims arising out of the same transaction or occurrence are being prosecuted in two different litigations. Because the California and New York actions involve the same insureds, the same underlying events, and similar coverage issues, a clear potential exists for inconsistent and mutually contradictory determinations. That's a good argument. Harco also incorrectly suggests that the Colorado River doctrine only applies in actions involving federal policy or a unified state system. But courts exercise abstention in actions involving common law torts and contract disputes. The question is whether the actions overlap. The order of filings is irrelevant. Harco's reliance on the first to file rule is misplaced because that doctrine applies to concurrent federal litigation, not concurrent state/federal litigation. And filing order is generally inconsequential when, as here, actions are filed close in time. Harco cites employers' insurance of Wausau against Fox Entertainment Group for the proposition that the first filed rule applies, but employers is inapposite. The Second Circuit remanded the case to the district court to determine which forum was more appropriate. The first filed rule does not constitute an invariable mandate. The inquiry still requires selection of the more appropriate forum. Harco's filing here was impermissible forum shopping. After receiving a response from the Insured's Coverage Council on June 20th, 2025, disputing its position and promising a formal letter responding to Harco's coverage position, Harco filed this action before receiving the letter with no prior notice. Harco's excuse for filing in a jurisdiction it clearly believed was more favorable to it is some fear of avoidable damages that might accrue while waiting for counsel's promised communication. Harco does not elaborate, and there is no evidence of any such damages. If Harco appropriately investigated the insured's claim and denied it in good faith, then what avoidable damages concern it? Of course, if Harco breached his duties, then the insureds have suffered and are suffering damages, but why would Harco's breach justify proceeding in a less appropriate court? It does not, nor does Harco show that resolution would come faster here than in California. Harco also relies on an inappropriate and inapplicable case law. In Harleysville Insurance, the insurer sought declaratory judgment after providing a defense for 2 years, and the court found that declaratory relief would resolve uncertainty as to whether or not Harleysville may terminate its cost sharing and refuse any coverage without subjecting itself to liability for failing to comply with its contractual obligations. An insurer filing first may make sense when the insurer is paying. But the comparison to the facts here undercuts Harco's argument. There is a significant difference between cases involving insurers filing suit after years of paying defense costs and Harco filing suit within a month of awaiting a follow-up coverage letter without having paid a penny to its insureds. That's good. The insureds are the parties most interested in a prompt resolution because they are the ones being deprived of one of the most important benefits promised by Harco, a defense paid for by Harco. Rather than protect its insured's interests as it must do, Harco has sued its insureds, forcing them to litigate 2 coverage lawsuits while leaving them to defend the lively lawsuit on their own. California is more convenient and choice of law favours abstention. As addressed above, New York is not the more convenient forum. Choice of law also favours abstention because a California state court is uniquely qualified to handle the insurance law issues central to the case. California has a particular interest in ensuring its insurance laws and regulations are properly followed and applied. Wayfarer and the Enzo's movie have their principal places of business in California. Mr. Heath and Mr. Baldoni both reside in the state, and the insurance policies were purchased and contracted for in California, facts which satisfy the choice of law factors. Harco's dismissal of Pasalacqua builders as a red herring is unavailing because abstention does not alter the choice of law analysis. The cases on which Harco relies do not help it either. Right, and then they go through the cases, which I won't do. The convenience of litigating Harco's claims in California weighs in favour of abstention, as do most of the other Brillhart Wilton factors discussed herein. And I did have to laugh at Harco suggesting that New York was convenient because Blake Lively is going to be a witness and she lives in New York. Like, all that was missing was the Blake Lively Instagram post of the, her wearing the jeans, being a New York lady. But I mean, her being a witness, she can, she doesn't have to travel to California. It's highly unlikely that she would need to travel to California to be a witness. She can, do depositions over Zoom. And she can still pass documents and various things, electronically, as she is probably doing right now. She's not going to her law firm, with handfuls of documents. So I don't know why Harco even attempted to argue that New York should be the correct forum because it's convenient for Blake Lively. That one struck me as odd. Anyway, so the conclusion, the insureds respectfully request that this court grant their motion. I thought it was a really, really good argument, actually. I mean, I did think Harco argued well in their opposition, but I said, I want to see what Wayfarer respond with, and I'm not disappointed at all. Okay, so we've got a couple more letters that have been filed, and I'll do the videos for them, and I'll be back soon.